The country's courts are once again expected to take center stage with several high-profile matters set to resume. From the long-running Senzo Meyiwa murder trial to the escape and fraud case involving Thabo Bester, as well as the charges facing the likes of Vusimuzi Matlala and his co-accused, there are many matters that are likely to dominate the legal calendar for 2026. The coming months are expected to test the pace, credibility and the resilience of South Africa's justice system. So let's take stock of this for you and bring in attorney and director at Dubazana Attorneys. That's Nthabiseng Dubazana, who has been gracious enough to join us in our studios this Wednesday. Great to see you. Thanks very much in time, indeed, for coming through. And you and I were speaking off air about where to begin, because there's just so much that's taken place. And I think as a disclaimer, we should say up front, we're unlikely to cover all of them. But there are some that I think are top of mind, even for people watching this morning. And perhaps we'll kick things off with what's been taking place in the High Court in Pretoria. The Senzo Meyiwa trial last year, I beg your pardon, the state finally wrapped up their case with the defense beginning their arguments. But there are still so many delays along the way.
Yes, so the state having wrapped up their case after maybe 7 or 8 years, or if not more, if we consider the time frame of this matter. But be that as it may, the defense is now having their opportunity. But with that, we are seeing that there's things that involve the threats of the court officials towards the end of the year. So that kind of hindered the process of the court and the progress of the case in itself. And then there was obviously the interaction between Advocate Mnisi and the presiding officer, and that never really goes well most of the time. And if memory serves, he was putting in an application to have rest or to go at least consult with a doctor for his mental stability to consider to continue with this case. Because part of the threats that were leveled against court officials involved the defense counsel. So he felt that he's not safe. So he felt that he needs to really come and bring himself towards himself and then see if he can proceed with the matter. That now leaves a lingering question as to whether or not he'll actually come back. And if he doesn't come back, he has to come and withdraw as attorney of record. And if he does do that, we're stuck in a very terrible predicament, because this means that the court now has to allow the accused persons to get a new attorney.
Gosh, and we know what comes with that,
yes.
Right? More delays as the attorney goes through the documents, the evidence, etc., etc. It's a story we've seen so many times
in this particular case.
Speaking about delays, the Thabo Bester matter has also had its fair share of those kinds of interlocutory applications. Help us get up to speed with what's happened so far and how things are likely to unfold this year.
All right, so the trial was supposed to start in February, and then it got postponed to, I think, the 20th of July this year. And the reasons are that because Thabo Bester is challenging his extradition case. Nandipha is also doing the same. It's in the Constitutional Court. If these two in particular are successful, I doubt, but if they are successful, then it dictates directly to the consequences of whether or not this case can proceed in July. Because if the arrest is deemed to have been unlawful, everything that follows from that falls away. So which means the case in its entirety now would fall away. So the state would have to really consider whether or not they can proceed. Because in terms of Section 35 of the Constitution, it says that suspected persons as well as accused persons have a right to be heard in a fair manner, and part of which is that you should be brought in within 48 hours, and then over and above that, your arrest must be legal. So if the detention, extradition, I beg your pardon, from Tanzania to here is deemed to be unconstitutional, then it means every other evidence that has been acquired as a direct result of that should be deemed inadmissible within the trial. So it's going to throw a dent within the actual main trial. So we have to wait and see what's going to happen there. And then he also made an application for his assets, the money, to be unfrozen. I don't know what is going to happen there. I don't even know what bearing it has on the case. But his attorney says that he needs funds to pay for his attorney, so therefore the accounts must be frozen. But if I'm not mistaken, the accounts are frozen as a direct result of him having escaped the country or prison, to be specific. So they are part of the main trial in itself. Then over and above that, he is also making an application. It is the extradition, it is the money. He's also talking about his accommodation, for
right.
lack of a better term.
The conditions under which he's being kept in prison.
Yes.
Right.
And the court really doesn't have much of a say in that. The only thing I can think about is when we deal with the Bill of Rights and whether he's been treated correctly as a human being. But with that being said, his attorney is arguing that he is not a sentenced prisoner. Yes. In this case that we are dealing with, he is not a sentenced prisoner.
But of course, he's a convicted criminal.
That is correct.
Right.
So he still has to be treated as a convicted criminal within the correctional services system, because that's what he is. In this case, he is not convicted, true. But then what do we do with the conviction he's already serving? How are we supposed to now treat him differently? Because he is not convicted in the pending case, but he's already been convicted in other cases.
Yeah, so much also being said about his relationship with Nandipha Makudumana, even after their incarceration.
Yeah.
Those images, I think, are still very clear for people in their minds when it seems they were having a bit of an exchange. But I think, if memory serves, and you'll correct me if I'm wrong, Nthabiseng, Nandipha Makudumana has tried to separate herself in some instances from this case.
Yes, from what I've seen, it seems like the closeness we saw in the beginning has kind of dissipated a little bit. And when it comes to the many, many cases that Thabo Bester has versus her one that is now sitting in the Constitutional Court, she just wants to deal with her version of events. It's not inclusive of, because if it was still the duo, I believe that the appeal would have been dealt together together in the Constitutional Court. I'm not sure if the papers include Thabo Bester. I haven't seen the notice of motion to see if it includes all of that or all of the accused persons, i.e. her and Thabo Bester. So it seems that there's some sort of separation, and if that's usually the case, what tends to happen is that one of them ends up being what we call a Section 204 witness.
Can you imagine that happening?
That would be interesting.
Gosh, okay, there's a plenty to look out for insofar as that is concerned. Let's speak about this web of criminality that we're told has unfolded, affecting in some instances the justice system, and the murder of AKA DJ somebody, DJ Fintos, and there's a third one which I'm forgetting as well. But police have come out to essentially say, look, the firearms that have been used in many of these cases seem to be connected. Yeah. Where are we insofar as that litigation is concerned?
The downside of a great number of cases that involve firearms is that the ballistic reports take a very long time. Our labs are inundated and they don't have the kind of capacity to bring back information, the 212 reports, that's what we call them. So now, that's what I believe in the AKA murder case and Tibbs case that was missing, because the state had to now disclose, give the defense attorneys a chance to prepare, but the 212 reports from the ballistic were missing. So how do I then prepare with my clients as a defense attorney when I don't have full information? I do believe the court did put the state on warning to say they must get their house in order and make sure that they give the defense attorneys all the relevant information. And considering that all the accused are now finally in the dock, because the two that were extradited from Eswatini are now here, so we hopefully we will have a smooth riding. The only thing that would really be a hindrance, I do believe, would be the ballistic report. And if that is going to be the case, as a defense attorney, what I would do at least is that if, with the warning that the court has given the state, and they are still not ready, we make an application in terms of what you call Section 342, capital letter A. That means we are saying, court, the state is not ready, so therefore strike this matter off the roll, and then you can call us when you're good and ready and you prepared your case. If that happens, it means all the accused people go free. And if they go free, how are you going to round them up again when when the state is finally ready to proceed? Especially when you consider how long it took to extradite the Ndemande brothers from Eswatini. Exactly. So the hope is that when they do go back, I think sometime in February, if I'm not mistaken, then maybe the state will be ready to proceed and we can do pre-trial, etc., leading towards the trial. Sure. Before then, we should hear a bit more from Julius Malema's firearms case. Yes. Last year, there was a 3-day judgment that was delivered as part of the conviction, I suppose. What we expect this year is some kind of sentencing. Yes. So after the 3-day, that was actually quite odd. Right. Because usually when a magistrate or a judge has such a long judgment, they just read out the summary and then they hand out the full judgment to their attorney so that we can read it on our own. 3 days. Yeah. That was scary. But anyway, what we're expecting, I think the 23rd, if not the 26th of January, should be a pre-sentencing hearing. So what happens is that a pre-sentence report would be given to the court in terms of Section 260 of the Criminal Procedure Act, right? So a social worker would have interviewed Malema to find out, what his thinking is, just assess him. And then with that report, then there should be a recommendation that goes with it to say that based on X, Y, and Z, in my interview with the accused, I believe that a sentence should be in accordance to whatever section that the social worker would then recommend. And then with that, then the accused has an opportunity to go into the stand for mitigation, and then there's aggravation of sentence by the state, and then the court will then issue out a sentence.
And we have heard, I think, from the EFF leader himself that he even plans to appeal this particular judgment. So maybe there are more 3-day judgments loading, who knows. Let's shift gears once again and take us back to the criminal justice system. Dumisani Khumalo is still, of course, also in trial. He's the crime intelligence head. Last year when we left off, there was a decision to relax his bail conditions. One of them was essentially barring him from getting back to work. And when Nthabiseng Dubazana appeared before the Matlala Commission, he pointed to that as part of the efforts to frustrate their work as the PKTT and as police, generally speaking. Yeah.
So with the bail conditions being relaxed, in fact, being removed, that particular one barring him from going to work, it means now he's back conducting his duties. And if part of the duties per what Nthabiseng Dubazana said in the Matlala Commission, what he stated, if him being back means there's going to be progress in the PKTT, I believe that we're going to be seeing very interesting cases coming up as a direct result of that. But in any event, his main case that Dumsani his matter is still pending before the Pretoria Magistrates Court. I'm not quite sure if it is now within trial stage, I beg your pardon, or pre-trial stage. In other words, they're yet to talk about what is in conflict with each other, what is common cause, all of that, so they can settle on how they're going to proceed with the trial. But if between the date that the High Court actually set aside the bail applications and until now, the state's case has been weakened as a direct result, we may see something completely different. Because what I would think the defense attorney would do is then write what we call representations to the state to say, your case is lacking, and we're looking at the docket, and you don't have what we call a prima facie case for you to proceed against my client. And if that's the case, withdraw the charges. So if we're still at pre-trial, I'm anticipating something like that coming.
Fascinating. We also, in 2025, were exposed to a case involving a sitting magistrate, right? That's the matter involving the leader of the International Holiness Pentecostal Church. There you go, got it right.
Yes.
And Judge Portia Patlane has been implicated in receiving some kind of kickback to give out a favorable outcome as that church undergoes their succession battle. Of course, it caught so many people's attention because of how big the church is, but because now we're dealing with a judge in the dock.
Yes, and I believe it's alleged that she and her son received around about 2 million or so, but the case is still pending, which means investigations are still going on. Part of the bail conditions are that she is barred from going to the High Court or entering the High Court. That, I think, was probably not well thought out. Because she is, at the end of the day, a sitting judge. She has many pending matters before her. So if she's not permitted to go to the High Court, how is she going to hand over her current matters? So we are dealing with a situation of probably some of the pending matters she has, judgment has been reserved, which means she's likely has these cases at home because judges are going to type out their matters at home. They don't have time to do it in the courthouse. So who's going to deal with the judgments? Who's going to type them out? Because it means the matter has been concluded. Now, other matters, let's say it's a apartheid trial. What does that mean? Does that mean that the matters are going to be dealt de novo? And how is she going to hand over? How are we going to deal with that? I think perhaps the magistrate's thinking was correct, but maybe there should have been a different way in which saying that once you've handed over everything to the DJP, then you're not allowed to proceed to go to any court. So that is a little bit of a murky situation for her pending matters.
Sure. Let me tell you, Nthabiseng, we're not even halfway through the list. And I think if we try to go through all these cases, we'll be here all morning. But as you round off, I wonder if you can just give us your own reflections about this test that people feel the South African judiciary is currently undergoing. You know, we've had many an instance where magistrates have even been striking. I think it was in KZN because of poor pay. But generally speaking, even at a constitutional court level, there have been concessions that judges are under strain in this country. Given just the mammoth task that lies ahead, I wonder what your level of confidence is about, our ability to ensure that the judges that are given in 2026, or judgments, will stand the test of time, essentially.
We hope so, because we start litigation in the hopes of relieving our clients' problems. And we are hoping that the presiding officer we are appearing in front of is competent enough to proceed with that. But you just stated a very important part. They're very inundated with work, and there's not enough of them. And the criteria for hiring a judge, for example, is that you should have a minimum of 15 years experience. Who in the practicing field currently is going to let go of 15 years and then go and sit on the bench? It's not very enticing. I do believe recently I saw an interview on one of these podcasts, Magistrate Karikan from Randburg was talking about the same thing, saying magistrates don't even make enough money. So how are you even enticed to go sit on the bench? That's why they have so much work. They have over 50 attorneys appearing in one day. And with those 50 matters, they're expected to give a judgment. How are they going to do that when there's such a small number of presiding officers? And sometimes they don't even have the time to research, because we are putting pressure on them to say, where's my judgment? My client needs this relief. And then we report them to magistrates commissions or the judiciary commissions, whatever. And then with the judgments come out questionable, some of them, and then we are now appealing, and the cycle just continues. So the hope is that maybe the Department of Justice can probably deal with this situation of a shortage of magistrates and judges, so that we can have better judgments. Yeah, no, there's also been a lot said about having the judiciary operate independently, even as the funding is concerned. But let me not open that jug of worms. Nthabiseng Dubazana, great speaking to you as always. Thanks so much for popping by as we take stock, of course, of the big stories to look out for in the year 2026. Nthabiseng Dubazana, Director and Attorney at Dubazana Attorneys.